That statement, which reverberates all through our jurisprudence up to the present moment, informed the need for us to sustainably fight this battle. He called it the rape of the temple of justice, the desecration by the black mambas. Why the invasion? Because they were just exercising their mandate given under the Constitution to dispense justice without fear or favor, ill will or affection, and without any bias. Specifically implementing Article 28 of the Constitution, which talks about two things: the right to a fair trial and also civil liberties. And when you go to Article 44, the right to fair trial is non-derogable. We craved for a moment when the judiciary would rise to the occasion and prove themselves unequivocal on this matter. We are glad finally on the 31st day of January, they came out boldly. And in his own statement, the Chief Justice said, time has come for the judiciary to make a sober decision. I think it was in line with the notion of judicial activism. Sober decision reflecting on the spirit of the Constitution as embodied in the preamble and looking at the history of this country. So we commend them for the bold decision they took and for the pleasant surprise they gave to the nation. I'm sure many Ugandans did not see this coming, including myself. We are very, very skeptical about it, but it's because of our continued and sustained struggle, resilience and tenacity that we had to push this up to the point where we are today. A few things need to be clarified. Now, before I do that, allow me to restate this, re-echo this statement we made here, that we are determined at Katonga here to dismantle all the tools General Kaguta Museveni is using to entrench a personal role, a family role. And we are glad one of the tools now, one of the arms, one of the weapons he has been using has crumbled. Now, we are glad. And what makes it more exciting is that it has come ahead of time, because our expectation was that by end of the year, we'll have brought down this instrument. But just after 1 month, because we made the announcement in January, then 31st January, we are done with that. We have achieved that mileage. It's a huge, huge achievement. We must celebrate. A few clarifications before we give you the way forward. One, since the decision was made on Friday, there's been a lot of passionate discussion about this, animated discussion. There's been an animated discussion within the public domain on this very important matter. Unfortunately, there's been some misconstruction of the same, which we need to correct and put into proper context. Number one, General Kaguta Museveni issued a statement which was paradoxical. On the one hand, he was lambasting the justices of the Supreme Court for the decision they made. But again, in the same statement, is indicating that actually they are going to correct the wrong they made. So it is a paradoxical statement. But we take exception to the language he used in that statement. We do take strong exception to that the country is not governed by judges, that the country is governed by Museveni and the voters. We need to remind General Kaguta Museveni, we have a constitutional order in this country. The Constitution creates a conventional system of government, whereby we have three organs. We have the executive, we have the legislature, and we have the judiciary. Each of them operating independently. Now Mr. Museveni is sending signals that actually the only instrument, no, rather the only organ that has the mandate is the executive arm, where there are electoral processes. That because the judges are not elected, therefore they don't enjoy the mandate of the people. We want to remind him about the provisions of the Constitution, which clearly state that judicial power is derived from the people of Uganda. Let him read the Constitution. And that the judges are commanded to exercise that mandate for and on behalf of the people of Uganda. So the judiciary is as important as the executive and the legislature. We don't need to lecture Mr. Museveni so much about the structure of government in relation to the three organs of government. So that statement is very, very unfortunate, and we condemn it in the strongest terms possible. That is number one. Two, their commentators, I think it's their maiden voyage in legal interpretation, who are asserting that the General Court Martial, as we knew it before, still exists. If they are lawyers, they are novices. If they are politicians, they are disingenuous. The judgment was unequivocal, was very, very clear. The Constitution created a single-lane judicial system. No, never. Never did they suggest, the members of the Constituent Assembly, that Uganda shall have a dual criminal justice system. No. It's a single lane. Now we have been having a system whereby there are two sets of courts. You have the conventional courts, and you have those who sit at Machingi. And they pronounce themselves very clearly on this. That was never the intention of the framers or the progenitors of the Constitution. In as much as they recognized the historical significance or importance of a general court martial in instilling discipline within the military force, when it came to dispensation of justice, the justices were very, very clear on this. So Parliament exceeded its mandate in enacting the UPDF Act in 2005 by creating two things. One, the provision, that is 117, which is now 119, that vested mandate in the General Court Martial to try civilians. Civilians of two categories. Those who were said to have brought themselves within the purview of the General Court Martial by either abetting crimes committed by serving military officers, or those who wielded weapons which had been considered the monopoly of the UPDF. Now, that animal, we asked when we were in the General Court Martial, that animal, a weapon which is ordinarily the monopoly of the UPDF, which one is that? It was the same question before the Supreme Court. Which one? It has never been defined. So in other words, there is no weapon which is a monopoly of the UPDF. And that's where Parliament went wrong. They also went wrong in that suggestion that even soldiers who are charged with capital offenses that attract serious and grave penalties like a death sentence or life imprisonment that they can be tried by a tribunal which was not competent, manned or presided over by people who did not have necessary qualifications. So that's why they had to nullify Section 197 of the UPDF Act, which created the General Court Martial and never defined the qualifications for the members of the General Court Martial, save for the chairman, whom they said shall be at the rank of Lieutenant Colonel. But Lieutenant Colonel of what qualifications? You can be a Lieutenant Colonel but not a lawyer. You can be a medical doctor, you can be anything. But as long as you are Lieutenant Colonel, that you could qualify to be the chairman of the court. And also, so, in other words, there are systemic problems or defects within the system which the justice has faulted. So, in a nutshell, the point I am driving at is that the General Court Martial was disbanded because the provision that created it, Section 197 of the UPDF Act, was nullified. So, as we speak today, there is no General Court Martial. So if in your speak or in your talk, you refer to that outfit, the residue of it, as a General Court Martial, your statement would be unconstitutional. It would be actually, it would amount to contempt of court if you call this so. So from today onwards, please, nobody should be speaking about the General Court Martial. You can add adjectives as you want. The defunct General Court Martial, the former General Court Martial, the whatever, or whatever, the late. So there is no General Court Martial as of 31st January 2025. That is the new legal regime. That point I wanted also to emphasize it. Now, the last one is the issue of amendment. Amendment to the UPDF Act. In his statement, Mr. Museveni said they are going back to the drawing board. They are going back to Parliament to revisit the UPDF Act. Of course, there are a number of provisions, Section 2, Section 117, Section 100, that's a number of written of provisions that were nullified by the Supreme Court. So now he's saying they are working with the Attorney General and all those people in government to address those flaws in the Act and then come up with a new one. Take a note of the fact that there is a bill already pending before Parliament for the amendment of that same Act. There is one already where I think they wanted to legalize SFC as a unit of UPDF and a couple of other things they wanted to fix. So you can see they have already been tinkering with the UPDF Act. Now he's saying probably that they are going to withdraw the bill. That's what I think. Implicitly, he's suggesting that they are going to withdraw that bill and panel beat it and resubmit it to Parliament. We need to caution them. In law, there is what we call structural interdicts. Structural interdicts, these are consequential directives given by court after analyzing flaws within a system, defects within a system, and say, please, we have diagnosed this problem within the system. Do a surgery to the system and correct them as follows. This is what court observed and said systematic, they are systemic problems, not systematic, systemic problems. They are those issues which needed to be addressed, and they guided properly on how they can be addressed. So, if Mr. Museveni is going back to amend the law, well and good, but it must pass the constitutional test. it must pass the constitutional test in 2 ways. Number 1, he should not in any way attempt to overturn the decision of the Supreme Court. That is the command in Article 92 of the Constitution, which is very, very clear, that Parliament shall not enact any legislation that has an effect of altering or in any way affecting a decision of court. So once court has pronounced itself on a matter, Parliament can only reinforce the decision of Parliament but not to upset it. Or the decision of court, rather, not to upset it. So, the talk now, this is now where the issue comes in, the issue of the disciplinary committee. That defunct General Court Martial cannot automatically morph into a different outfit, even if it is to operate as a disciplinary committee, because the provision that created it, Section 197 of the UPDF Act, has since been nullified. Therefore, for it to morph or to transform into something else, from a General Court Martial with a wide mandate to a committee with a limited mandate of discipline within the force, it has now to be the Parliament. And the court guided that if Parliament is doing it, they should be, they shouldn't be oblivious of the limit under Article 210 of the Constitution. Under Article 210, which gives Parliament the mandate to make a law regulating the functioning of UPDF, is very clear. It's about to discipline. That's what they say. It's about to discipline. And they should not in any way provide for sanctions, penal sanctions, that involve custodial sentence or any other penalty like execution, death, or whatever, and so on and so forth. That is a preserve for the conventional courts. Theirs, under Article 210, if Parliament is to make a law that passes that test, theirs should be limited to disciplinary actions that would entail like caution or dismissal from the force. It can be with the disgrace. And it's obvious, it's just logic. Logic. Many of these entities have got disciplinary units, like the prisons authorities. Do they send people to the gallows? The prisons? The police? The police standard unit? The professional standards unit? Yes. Even Parliament, the Committee on Rules and Discipline. Can they remand you? Can the chairperson, Honorable Katuntu, remand an MP or convict an MP and send him to the gallows? It's only logic. So that's the way it should operate. That was the guidance. And they indicated, they went further and said, if they want to add them extra jurisdiction to handle issues to do with the civilians and even serving military officers who commit those offenses within the realm of the penal code, those ones should be handled by competent people who have gone to the law school, and not only to the law school, but who are qualified to be judges of the High Court, because to be a judge of the High Court, you must have practiced for at least a period of 10 years to be able to try capital offenses. That's why you cannot be tried by magistrate court, because there are no qualifications of that nature, that for you to be a magistrate or a chief magistrate, you must have practiced for a particular period. So therefore, if a chief magistrate of Uganda Road cannot try Dr. Besigye on a capital offense, who is this man, Sujui Brigadier General Freeman Mugabe, who has never gone to the law school, to try Dr. Besigye on a matter which involves death sentence? That is an absurdity. So this is where we take exception to General Kaguta Museveni in his statement. He said, you see, because he has indicated they are going to defy, he said, you see, if some jurisdictions provide for a law on homosexuality, where a man can marry a fellow man, why not having a system here where people who have voluntarily brought themselves within the ambit of the of the military law to be subjected to martial law? That is the analogy he was drawing. We are asking with General Museveni, with all due respect, please, you know I'm sorry to digress a bit. The Arsenal fans have got this cliche they are using to send a message to Haaland. Please stay humble. Yes. The Arsenal fans have told Haaland, please stay humble. We are telling General Kaguta Museveni, please stay humble. Just swallow your humble pie. You lost it on Friday. There is no way you are going to resuscitate the general court martial within the existing constitutional framework. I'm assuring you. There is no way. Let him be advised properly by the Attorney General and all those legal gurus he has in his government, if they still exist there. There is no way he can resuscitate the defunct general court martial within the existing constitutional order. It is absolutely impossible. I want to assure him. Parliament cannot do it. Under Article 92, it's very, very clear. You cannot. So that one, we wanted to make it abundantly clear to General Kaguta Museveni, to ask him to swallow his humble pie. And now the way forward. Honorable Semju told you here, we assembled this morning in light of all that, just for one thing, to receive Dr. Besigye and Obedi Rutare. It's the reason we took a decision and said we cannot go back to March India. There is no business there. Allow me salute all the lawyers on the team. They are seated here. Thank you for the job well done. We have fought a good fight, and the results are on the wall. The other thing is about working out mechanisms of securing release, or the release of all political prisoners, including one of our own, our colleague, the indefatigable Kiza. Kiza did nothing before that committee. He was executing his duties, his professional duties, just like many of us have been doing there, and he had to suffer that fate. So we expect Dr. Besigye, Obedi Rutare, the NUP activists or leaders, and Kiza, together with all those political actors, prisoners of conscience, who have been facing the wrath of this general court martial, now defunct, to be released today and now. They ought to have been released on Friday. So any continued detention is unlawful. And actually right now, the situation obtaining today, as we talk right now, it is Yoweri Kaguta Museveni versus the Constitution. The Constitution is commanding Museveni to release Dr. Besigye. Now Museveni is resisting the Constitution he enacted himself. Shame. It's a command of the Constitution. What the justices of the Supreme Court did is just to restate the spirit of the Constitution. There were no innovations. There were no new things. They didn't read anything into the Constitution. They were just breathing life into this document called the Constitution, which had since become a paper tiger. And that's one reason we are commending them. They are breathing life into that document called the Constitution. So it's the Constitution one side, Mr. Museveni standing the other side. Now the battle is on. Where do we stand? So the choice is upon you all Ugandans to tell us where you stand. Do you stand with Mr. Museveni or do you stand with the Constitution? Where do you stand, Ugandans? It's a question. It's not for all of us. It's not for us who are seated here. For all of you Ugandans. Those who have been asking us, what is next? We are asking you Ugandans. Article 3 is very clear. The obligation, the onus is on all of you to ensure that this judgment is enforced. This is not a Kabaziguruka decision. You know, when you have that matter in the law, we call it a judgment in persona. When you have a judgment in persona, after the pronouncement is made, you extract the order, it is signed, we call it a decree, you take it to the bailiffs, and the court brokers enforce it. But when there is a judgment in a realm, there are two types of judgments. A judgment in persona and a judgment in a realm. A judgment in a realm, a judgment in persona binds the parties. If it were Kabaziguruka versus somebody else, it would be a judgment binding two parties. But a judgment in a realm is a judgment that binds all of you, whether you are in court or not. So the matter, the decision in the Supreme Court given the Kabaziguruka matter is a judgment in a realm which binds all Ugandans. One, you are obliged to observe it. Two, you are duty bound to enforce it under Article 3. Am I communicating? You have a duty under Article 3 to ensure that it is implemented. So, ask yourself, what have I done to ensure that Dr. Besigye is released? What is it that you can do within your capacity to cause the release of Aaron Kiza, to cause the release of Obedi Rutale, to cause the release of Dr. Besigye, Bobby Young, Machete, and others? There are so many. So ask yourself, if you have done nothing, you are committing treason under Article 3 of the Constitution. But what are we going to do ourselves? From here, a couple of things that are going to be done systematically and in a phased manner. Of course, we're not going to highlight all of them. There are those that are going to be, this judgment has to be implemented in different phases and also spheres. There are those who are going to implement at a parliamentary level. There are those that may require going back to court. There are those that are going to be implemented within the public domain. It's just going to be, a multifaceted approach. A multifaceted approach of enforcement. So this is what we are going to do. But today, what we are going to do today and now, the lawyers have assembled here. Our colleagues from different parts of the continent are waiting for us somewhere. You know, our team is led by none other than the Honorable Senior Counsel Martha Karua from Kenya. She's already in the country. She's with us waiting here. So we are going to liaise with her from here as lawyers. She'll be leading us to the office of the Commissioner General of Prisons peacefully to cause the release of Dr. Kiza Besigye, or to receive him and Obedi Rutale. So, just like we have been going to the chambers of of Justice Owinyi Doro, you recall we went there and he had to take a swipe at some of us in the judgment. In the common parlance, and now in the ghetto speak, they call it a gari. tuyisaamu eggaali. But we took it with humility. So, just like we have appeared before different offices, government agencies, to ensure that there is compliance with these orders. So we are just going to, in a very courteous and humble way, ask, and no, Mr. Byabashaija, the Commissioner General of Prisons, that please, the decision of court is very clear, and the remand warrant, which had been given, no, the remand warrant has since lapsed, one by a fraction of time. Today, it was expiring today. They were ordered to keep Dr. Besigye on remand until 3rd of February. Yes? By 9 a.m. today. So it has since expired. But even if it had not expired, the moment the Supreme Court directed that all proceedings be terminated on Friday, and the decision took immediate effect. So the remand warrant had been quashed by the Supreme Court. So the Supreme Court quashed it on Friday, but even if by extension of any logic, they were to contend that it continued up to today, then it has already lapsed or expired. By 9 a.m. today, 3rd of February, it has expired. Therefore, there is no more justification, there is no more reason as to why Dr. Besigye, Obedi Lutale, and other political prisoners are still in the custody of the prisons authorities. So without any further ado, and I want to end on that note, we are going to link up with the Honorable Martha Karua, proceed to the offices of the Commissioner General of Prisons to ask him to give us our people. And we exchange pleasantries with him and leave. That is all. May God bless you. I thank you.